Good evening, everyone. Welcome to the second episode of When the Gavel Strikes. Tonight we're going to be talking about real estate in real life scenarios. My name is Cherie Morris. I am the principal attorney for my firm, the Law Office of Cherie Morris, LLC. I am licensed in Alabama, Georgia, and Mississippi. I practice three practice areas: family law, real estate, and personal injury. So let's dive in. Tonight's episode is going to be really quick, but we're going to talk about some important things that you may or may not know. And feel free to chime in with any questions that you may have. So the first thing on my list today is title insurance. So most of you who have purchased a home or are purchasing a home may have made or may not have heard about title insurance. So what title insurance does is ensure that no one can come before you or after you and say that they have a legal right to your property that you don't. So take for example, you buy a home, the sellers say that they're going to give you a deed, and they say that we warrant that we own the property free and clear, no one else can claim it. Well, they didn't do their research, so someone else had a superior lien against them. So what that means is someone else had claims to the property and they owe money. So that someone else can now come and sue you and say, hey, we want our money on this property, or we can put your property up for sale to get our money. So the purpose of title insurance is to have someone back the mortgage or your property or your deed and say, we're going to protect you and defend your rights against any other person that tries and come against you. So that's what title insurance is in a nutshell. It is really important. Some people who get the mortgage say they don't want to purchase it because the lender requires it and they don't want to get their own owner's title insurance, but it is a really good investment because you just really don't know. Sometimes when people are doing the title search, they miss documents, they misread documents, and then certain things can be misconstrued. So you really want to have that protection. It's just like car insurance. You wouldn't, by law, you can't drive a car without having the insurance. So you don't want to have a huge investment in a home and then have someone take it away from you for nothing. So definitely always get title insurance if you're purchasing a home, whether you're buying it cash or whether you get a mortgage. If it's going to be your personal home, you definitely want to have the title insurance on there. Okay, so the next thing is talking about the quit claim deed. So I know lots of people have heard about a quit claim deed and they want to know what it is. So a quit claim deed basically gives the new buyer all the rights that the seller has. It doesn't go back before the seller's title or anything like that. And they are typically used in situations of divorce. So if a husband and wife have a home and in the divorce, say the wife gets to keep the home. So now the husband and the wife must create a quitclaim deed from the husband and wife as joint tenants to the wife by herself. So that all that does is remove the husband from the deed. Now, it doesn't get rid of the mortgage if the husband is on the mortgage. So a lot of people think that when they do the quitclaim deed and they say, oh, I was off that property, so that's no longer my responsibility. Well, you're still responsible for the loan that you have. So in order to get out of the loan, that is something that you have to work out with your mortgage lender, whoever holds the mortgage. So what you would do is take your divorce decree and the new quitclaim deed to your financial backer. If there's a physical place you can go to, you can do that. Or if there's someone you need to call and fax in or mail in the documents, you just let them know that you recently got a divorce and that you're no longer responsible for the property and you want to be off the mortgage. Oftentimes they'll work with you and tell you, yes, you can be off of it. Sometimes they will require, say, the wife to do a refinance in just her name alone so that they have all their ducks in a row. So a quitclaim deed doesn't necessarily get rid of the mortgage, but it definitely gets rid of all your ownership in the property. Okay. So let's switch over to landlord tenant. I get a lot of questions about, tenants' rights and landlord's rights. The first thing I want everyone to be mindful of is to always, always, always read your lease. I know it's like 10 pages long. The font is always like 8 point, so you don't really want to read it, but you need to read it because you need to know your rights. All of your rights are in that contract. In order to do anything with real property, whether it's buying a home, whether it's getting a lease, an apartment, anything for 1 year or more, it has to be in writing. So all of your rights are really in that document. So you definitely want to pay attention to that. And I'm just going to point out a couple of things that you really should pay attention to. One, you should pay attention to when your rent is due, so what day your rent is due, when your rent is late, what day that the late fee kicks in, how much the late fee is. If you are late and they have to file a suit on you, you want to know how much you're going to have to pay to do that. Sometimes it's just court costs. Sometimes it's court costs plus any attorney's fees that the apartment complex have to incur. So you definitely want to look at that. You also want to look at what you need to do in order to break your lease in case there is an emergency and you need to get out of your lease sooner. So there's always what's called a liquidated damages clause or reletting clause in the lease. And what that basically does is tells you if you want to get out of your lease before your 12 months is up, you have to pay the equivalent of 1 month's rent or 2 months' rent just to relet it. So those are things that you want to be mindful of. The other thing you want to be mindful of is what is the landlord's responsibility for repairs. So I get a lot of questions about when someone say, well, this is wrong in my house, the landlord is supposed to fix that. Well, certain things the landlord is supposed to fix, but certain things the tenant is responsible for fixing. So all of these things that I'm mentioning are really going to be in your lease contract. So make sure once you sign that lease that you have a copy of it so you can go back and read it and go through a fine-tooth comb, because there's plenty of things that you may not know about when you're reading it. And granted, the leasing agent or the manager is going to go over the lease with you, but they're only going to go over some of the important things that they feel like you need to know. And there's also other things in there that you may get caught up on if an emergency situation happens or something happens and you just really need to get things done. So that's definitely always do that. The next thing is what I like to call, or what's called repair and deduct. So most states, and in Mississippi and Georgia, they are repair and deduct states. So what that means is if you give your landlord notice that something is broken and it needs to be fixed, and they do not fix it within a reasonable time frame, and that reasonable time frame is usually about 30 days, then you can yourself get it fixed, provide your landlord with a receipt, and deduct that amount from the rent. Now, in order to do that the right way, you have to first give your landlord notice, and you have to give them a reasonable time to fix it. So like I said, 30 days is usually that reasonable time. Anything outside of that 30 days, then you should be going to go and get it fixed yourself. So what you should do is really get 2 estimates so you can compare, so you can say you did your due diligence, so you're not just going with the highest one or the first ones that come along. So you get 2 estimates for the service that needs to be repaired, and then you can pay for it. And then you ask for reimbursement. Sometimes the landlord will reimburse you. Sometimes they'll even offer and say, okay, if you get it fixed, I'll just reimburse you, or you can subtract it for next month's rent. So always ask for reimbursement first before deducting it from the rent. So once you've asked for reimbursement, they either don't give you an answer or say they're not going to reimburse you, then you can submit the receipt with your with the lesser amount of your rent. So say if your rent is $500 and your repair costs $200, then you submit the receipt with your $300 rent check and say, this is why it's $300 because I had to pay $200 to get the repair. Now, the only way you can do the repair and deduct is if your services are less than what your rent amount is. So if your rent was $500, you can't go and get some services that cost $600 and just not pay rent at all the next month. That's not how it works. But if your services were $400 and your rent is $500, you can definitely do that. So just be mindful of that. And the last thing I want to talk about is security deposits, because everybody wants their money back once they're out of the apartment. So usually how you get your security deposit back is in your lease contract. So you definitely want to read your lease and see what they will withhold your security deposit for. The usual things that they withhold it for is for if you leave the property damaged, if it's in disarray, like say you didn't clean the carpets and the carpets are just absolutely filthy to the point where they have to be replaced, and they have to be replaced because of your tenancy and not previously, then that's something that they can withhold it for. If there is some extreme damage to the walls, there's holes in the walls, there's things like that that cannot be replaced by just normal maintenance, they have the right to withhold your security deposit for that. Anything outside of damage to the property, they really don't have a right to withhold your security deposit unless they put that information in your contract. So always read that. And if they do not provide you with your security deposit back, the only way you can get it back is to sue them for it. So you have to sue in the equivalent of, it's either small claims court, or you're going to be in whatever court that has jurisdiction over dispossessory, landlord tenant, or property issues. So in Mississippi, that is either Chancery Court or Justice Court. And in Alabama, that's going to be, not Alabama, in Georgia, that's going to be Superior Court. So those are the type of things that you want to be aware of and be on the lookout for if you're going to be dealing in the realm of landlord tenant and renting your apartments and things like that. But the most important thing for renters is to read your contract. Whether you're renting a house or renting an apartment, you want to read your contract. Always have a copy of it. Don't let them not give you a copy of that lease before you leave from signing. And that is it for today. If you have any other questions or something that I didn't talk about that you want specific questions for, you can always reach me by email at Shari, SHARI, at ShariMorrisLaw.com. You can reach me by phone. If you're in Mississippi, the number is 601-460-1779. If you're in Alabama or Georgia, the number is 770-966-3244. And you can always reach me on Facebook, Twitter, Instagram at Facebook / Shari Morris Law, Instagram / Shari Morris Law. So anything that I didn't miss, or if you want to know more, feel free to contact me. And that's it for this episode of When the Gavel Strikes. Tune in next month for the next one.